Good morning. This is the Tuesday, June 23rd meeting of the Assembly Judiciary Committee. Welcome. I'm Mike Fewer. I'm the chair of the committee. We will soon have a quorum. In the meantime, why don't we begin? Let's see, who is here? Ms. Corbett, I believe. Ms. Corbett is here on item number 9 and item number 12. Item number 9 is SB 320. The esteemed chair of our Senate Judiciary Committee. Welcome, Ms. Corbett.
The red button. Good morning. Thank you very much, Mr. Chair and members. Senate Bill 320 would prohibit state courts from enforcing a defamation judgment obtained in a foreign jurisdiction unless a court determines that the law provides at least as much protection for freedom of expression as offered in our U.S. and California constitutions. Currently, people not able to win a libel judgment in the United States because of our constitutional protections are bringing actions in libel-friendly countries like the United Kingdom and gaining default judgments against Americans. U.S. courts can then be obligated to uphold these judgments. The amendments clarify that the courts can determine the standard of libel at the same hearing as when they determine if the judgment should be upheld. Freedom of expression, as we all know, is a fundamental right in our country. The First Amendment, the California Constitution, and California's anti-SLAPP law all give authors, journalists, and average citizens the right to exercise their free speech rights. I just wanted to thank you for the excellent analysis, which points out very clearly why this is such an important law and how we can make sure that we continue to uphold due process and our freedom of speech in our state.
Thank you very much. Ms. Corbett, do you have any witnesses in support?
I do have witnesses in support, but I don't think they're here yet.
But you beat them to the podium.
Yes.
Is there anyone here in opposition to this measure? All right. Seeing none, in the absence of a quorum, which we will have in a moment, Ms. Corbett, why don't you proceed to your other matter? Oh, before we go on, is there anybody with a question for Ms. Corbett on this matter? Okay, very good. Why don't we proceed to your other matter, which is item number 12, SB 641.
Is 556 on consent?
Oh, excuse me.
That's Committee on Judiciary?
Yes, please. Item number 11, item 556.
Okay, thank you very much. Senate, I believe this has support on both sides. Senate Bill 556 makes two non-controversial changes to improve court operations. The bill clarifies the law governing post-judgment fees in small claims court and also clarifies that a court is authorized to submit unpaid bail amounts to the Franchise Tax Board's court-ordered debt program. There's no opposition to the bill. It's received bipartisan support. It is a committee bill, and on the Senate side, just for the members' information, we're required to have support of all members of the committee before submitting a committee bill. So this bill should be in good shape.
Congratulations on the unanimity, and you do have a witness in support on this matter.
Good morning, Chair and members. Dan Pone from the Judicial Council, the sponsor of the bill. It is a technical clarifying court operations bill that will help improve our operations, and we ask for your aye vote.
Very well. Is there anyone else here in support of this measure? Is there anyone here in opposition to this measure? Seeing none, members of the committee, any questions on this matter? Seeing none, again, we have no quorum yet, so we will proceed to your next item, which is item number 12, SB 641. I should mention, I have neglected to point out that on our committee this morning, we are joined by our colleague, Mr. Silva, who is here replacing Mr. Nielsen, who's in the midst of continuing budget discussions. Mr. Silva, welcome to our committee today.
Thank you.
Very good. All right, Ms. Corbett, thank you very much for your patience. Please proceed to item 641.
Thank you very much. This is Senate Bill 641, the annual State Bar Dues Bill. This year's bill permits the bar to charge membership dues for 2010 up to $410, and as the analysis points out, this is a flat dues bill. There's no increase in dues this year. I think it's appropriate given the bar's fiscal situation this year, which will allow them to continue to operate without significant cost reductions or dues increase into 2011. The data made available didn't justify the case for an increase this year, but we do recognize that there may be some need made for that in future years. This bill will allow the bar some flexibility also by clarifying that the bar can transfer fees collected from law corporations and LLPs for registration to their general fund to assist the bar in its regulatory and disciplinary processes. This change will allow the bar to transfer $1.2 million on an annual basis to be used for these purposes. In addition, SB 641 updates the bar's information technology contracting procedures so they are more consistent with our state procedures, and the bill would allow the bar to increase the dollar amount for informal competitive solicitations for IT contracts from $50,000 to $100,000. This change would apply to IT contracts only. This bill was heard in the Senate Judiciary Committee. It was amended to require the bar to report to us on how this change is working, and amendments were also taken to require the bar to have a preference for using in-house employees on IT projects whenever that's possible. I understand that the Center for Public Interest Law has requested a few amendments to require an audit of the Lawyers Assistance Program, and I agree that this is a very good idea, and it's time to take a look at it. I'm working with them and the Bureau of State Audits to ensure that this is part of the next performance audit of the bar, which is due in 2011, and I believe we have addressed their other concerns. And I ask for your aye vote on this measure as well.
Thank you very much, Ms. Corbett. You have a witness here in support.
Thank you. Anthony Williams on behalf of the State Bar of California. We're the sponsor of the bill, and we'd like to thank Senator Corbett and this committee also for your work with us on this bill. While it does not provide for an increase this year, there is a recognition that going forward we will have to address the sort of coming budget crunch. The State Bar has sort of tightened our belts a little bit over the last few years in order to allow us to permit us to operate through this year. And we look forward to working with you next year and beyond to address the bar's fiscal issues.
Thank you very much for the testimony and for the warning. Is there anyone else here who wishes to testify in support of this measure? Seeing none, is there any opposition to this measure? Seeing none, members of the committee, questions or comments for Senator Corbett? Seeing none, we await a quorum. Thank you very much, Senator
Thank you very much.
Corbett.
It's always a pleasure to be here.
It's
Thank you very much.
Great to have you here. We are next going to be joined by our colleague, Mr. Leno. Senator Leno is here on two matters, SB 290, which is item number 8, and SB 781, which is item number 13. Senator Leno, welcome.
Thank you, Mr. Chair. Committee members, should we take them in that order?
Please.
SB 290, the tenant 60-day notice bill. As you well know, current law requires landlords issuing a no-cause or no-fault eviction to give tenants 60 days in which to move, recognizing the great difficulty and sometimes near impossibility of finding another rental in 30 days. Interesting history to this idea. It started as a pilot project in Los Angeles, Santa Monica, and West Hollywood back in 2001, and that was a bill authored by then Senator Sheila Kuehl, SB 985. It was expanded statewide the following year for a 3-year period, again authored by Senator Kuehl. That 3-year sunsetted in 2005, but Assemblyman Tirico then extended it 3 years to 2006. So we've had a real-life experience and experiment with this concept. Now, why it is important to give tenants more than 60 days is for a number of reasons. First and foremost, oftentimes this is protecting the most frail, senior, or disabled tenants, because when they're moving from one apartment to another, it's not just for a roof over their heads. They have a support community around them as well, physician, maybe pharmacist, others who are assisting them in being able to continue on with their lives. So 30 days often is not sufficient enough time. Additionally, of course, with first, last month, and security deposit, it can take a while to amass those kind of funds. And keep in mind that evicting landlord, and this, of course, is for a no-fault or no-cause eviction, the evicting landlord is allowed to keep the deposit for 21 days after the tenant moves out. So it really becomes a significant financial burden as well. So we have had this experiment. We've had this experience now for many years throughout this decade, And the good news is that it has indeed afforded the benefits that we imagined it would for tenants at minimal, if any, hardship for the landlords. And that is why the California Apartment Association, though they fought this significantly in the first years and when it was first proposed, now realize that their worst fears have not come true, and so that they are neutral on the bill this year. And so with that said, I would ask for your aye vote.
Thank you very much, Senator Leno. Your witnesses here in support.
Christine Menahan, Western Center on Law and Poverty. We are the sponsors of this legislation. The Senator has covered a great number of the reasons that we are once again sponsoring this bill for the fourth time. I would add only a couple of points. I know that the opponents have been saying that the need for this bill in 2001 was because the vacancy rate was extremely low, and therefore there is no need for that any longer. And what we have found before this bill was enacted and afterwards is that it's not so much the vacancy rate, although that contributes enormously to the difficulty in finding an alternative apartment. It is the fact that tenants, by their nature, are significantly lower income. Many of them work several jobs. Many of them are dependent upon bus systems to get them around. They're dependent upon childcare in the neighborhood. They're dependent upon a school system that is currently working for their children. And finding the time on the weekends or in the evenings to locate another apartment is very difficult. What we have learned from our legal services programs over the last decade is that the number of families that are making two moves, a move into a shelter, a move into another family's home while they put their goods in storage and then find something, that dual move is no longer necessary. Simply say that we urge an aye vote. Legal services programs around the state said that while this is not a huge, exciting benefit, it is sort of the meat and potatoes of being able to live in this economy in this state and be able to find alternative housing. We urge an aye vote.
Thank you very much, Ms. Minahan. Before we proceed to your next witness, Senator Leno, we now have a quorum. Would you please call the roll?
Fear.
Here.
Tran. Here. Brownlee. Evans. Jones. Knight. Krikorian. Liu. Monning.
Here.
Silva.
Thank you very much. Pardon the interruption. Your next witness, please, Mr. Leno.
Ronald Coleman on behalf of California Acorn. We believe that AB 290 is extremely important and essential to ensure that tenants have adequate and reasonable time to transition to new affordable housing. As you heard from my colleague, a lot of tenants are very low income people, and they often work several jobs. And finding affordable housing is a pretty difficult process when you have to work maybe 80 hours a week just to make and meet your basic needs. We also believe that it's important to have this time to ensure that people can take the time to save to get their deposit. In a lot of cities in California, it's pretty expensive to leave a deposit, and often you're leaving a first and last month's rent, and this can total up into $4,000, $5,000, $6,000, and in some cases up to $10,000. We believe that it's also essential to have this bill because people need time to find affordable housing that's convenient to their family life, convenient to their children's schools, and convenient to where they work. Without AB 290, tenants will be overly burdened with having to find affordable housing in a very short time, and this can often leave them displaced or even homeless. And we ask for your aye vote. Thank you.
Thank you very much. Other witnesses in support?
Charlotte Newhart with the California Foundation for Independent Living Centers in strong support.
Thank you.
Leilani Yee, Asian Americans for Civil Rights and Equality in support.
Thank you.
Monica Guillen. Ian from the California Apartment Association. We're kind of in that netherworld, neither in support nor opposition. But as Senator Leno stated, we are neutral on this bill for the first time in, about 8 years, and it feels good to be here. The reason we have taken a neutral position, I think it's important for the committee to understand that with our experience with the 60-day notice, we have found that we can work with it, we can work with tenants, and it has not caused an undue burden on owners, which is why we are no longer in opposition.
Thank you for your testimony. Please, next witness in support.
Brandon Tartaglia with Disability Rights California. People with disability often have a hard time finding affordable, accessible housing. This bill would just help out in that respect. Thank you.
Thank you.
Sherry Jenkins from the California Senior Legislature. We are in support of this bill.
Thank you very much. Are there any other witnesses here in support of Mr. Leno's measure? Are there witnesses here in opposition to this measure? You kept Mr. Leno wondering for a moment, but welcome.
Mr. Chairman and members, Dave Milton, California Association of Realtors, and we are in, as Monica indicated with CAA, in a unique position in that we have recognized that this 60-day notice has been quite successful for the tenant. What our position is we are opposed, unless the bill is amended, to take this advantage of this time to give that same notice requirement to the landlord on a tenancy that's longer than 1 year. What the primary landlords that CAR represents are those that own the single-family homes, the duplexes, the small rental properties, not the multifamily, not the ones that are capable of preparing for vacancies when they occur in terms of the resources necessary to re-prepare for re-renting when a property comes on the market. We very much think that much as the notice requirement for for tenancies that are less than 1 year is 30 days for each, that the notice requirement for tenancies longer than 1 year should be 60 days for each. And we would respectfully request that the committee hold on to the bill while we continue to try to work with the sponsor to come to an agreement on that point. Thank you.
Thank you very much. Are there other witnesses in opposition or something approximating opposition? All right, seeing none. Members of the committee, do you have any questions or observations on this measure? Seeing none, is there a motion on the bill? Okay, is there a second? It's been moved and seconded. Mr. Leno, would you like to conclude?
Thank you, committee members and Mr. Chair. I'll ask for your aye vote.
Thank you very much. I think this is an important measure, and I will be urging support for it. Please call the roll.
Fuhr?
Aye.
Fuhr, aye. Tran?
No.
Tran, no. Brownlee? Brownlee, aye. Evans? Jones? Knight? Knight, no. Krikorian? Liu? Monning?
Aye.
Monning, aye. Silva?
Sure.
Okay.
Earlier would be better, but it's certainly appropriate.
I was waiting, and I'm sorry I missed out. So
Okay.
I apologize. I feel that the landlord and the tenant are equal. They should be treated as equals. And if it were 60 days for both, I could support it. Against the landlord, I can't. So I'd be a vote no.
Thank you, Mr. Silva. Okay, so that measure has 3 votes. It requires 3 more. We have other colleagues yet to arrive. Mr. Leno, if you please proceed now to item number 13, SB 781.
Thank you, Mr. Chair. As your analysis synopsis states, this relatively non-controversial bill, which I could not agree with more, is co-sponsored by California Advocates for Nursing Home Reform and by Bet Sedek Legal Services. Just want to
Could you say that again, Mr. Leno?
with which I know you have some familiarity.
Yeah.
So the bill aims to protect some of the most vulnerable tenants in the state, and that would be our seniors. There are about 168 elderly Californians living in nearly 8,000 residential care facilities for the elderly, or otherwise known as RCFEs. And amazingly, we have very little, if any, oversight of these facilities, and none of the requirements of those facilities as landlords have in sharing with tenants what their legal rights are. So the bill will reduce the number of unfair evictions and the impact they have on residents by requiring just a couple of things. First, a proper notice of their legal rights and responsibilities before being forced to leave their homes, and additionally, information on alternative housing and care options should that need arise. And as I mentioned, existing law does not require that facilities provide residents with their effective date of eviction, their legal right to file a complaint or appeal the eviction, nor do they have to provide any alternative housing resources. So this bill will rectify this situation and provide some comfort, security, and certainty for, as I said, 168,000 elderly Californians. I'd ask for your aye vote.
Thank you, Mr. Leno. Are there witnesses here in support? Please.
Yes. Good morning, Mr. Chairman and members. My name is Pat McGinnis. I'm with California Advocates for Nursing Home Reform, and we, along with Betzedek Legal Services and Disability Rights California, are sponsors of this bill. There are nearly at this point 8,000 licensed residential care facilities in California with about 170,000 residents. In fact, the RCFEs, residential care facilities for the elderly, are the fastest growing component of long-term care in California. And while every year we approve about 1,000 more licensed facilities, every year we also cut back the oversight and responsibilities of community care licensing. At this point, these facilities, these 8,000 facilities, are overseen and visited about once every 5 years. What this bill does is it addresses one of the biggest problems we've got. Every year in California, thousands of residents are illegally evicted from these facilities, which have become their homes. These are their homes. They're residential care for the elderly. And SB 781 will address the thousands of problems that we have with seniors every year with illegal evictions by providing them with the notice of their rights. And that includes the date of eviction. That includes the resources of so that they can find alternative housing. That includes their right to file a complaint with licensing and community care licensing. And I want to add that we've worked very closely, the author's office and sponsors, with the Assisted Living Association to address their concerns, and we incorporated those into the bill, and also with community care licensing several times to address their concerns. I urge your support of this very simple but very important bill.
Thank you, Ms. McGinnis. Others in support?
My name is Sherry Jenkins. I represent the California Senior Legislature. We are in support of this bill.
Thank you. Others in support?
Brandon Tartaglia with Disability Rights California, in strong support.
Other witnesses in support? Are there witnesses here in opposition to this measure? Seeing none, are there questions or comments from members of the committee? Seeing none, I do want to say, when I was at Betzedek Legal Services, and this probably is almost 20 years ago, I was involved in advocating on behalf of a number of tenants of just such facilities who had confronted a truly severe hardship when they were sought to be evicted. This is a particularly vulnerable universe of people, many of whom don't have other family on whom to rely. This measure is simple, but this is a very important issue. From personal experience, I can say the disruption is hard to describe in the lives of these residents when they are sought to be removed from the place that they've called home. So, having said that, other questions or comments? Is there a motion on the bill? Okay, it's been moved and seconded. Mr. Leno, would you like to conclude?
Thank you. I think your remarks are particularly appropriate. This is about consumer awareness for our most vulnerable tenants and just gives them the information they should have about what their current legal options are. Nothing more, nothing less. Ask for your aye vote.
Thank you, Mr. Leno. Please call the roll.
Fear?
Aye.
Fear, aye. Tran? Aye. Tran, aye. Brownlee? Aye. Brownlee, aye. Evans? Aye. Evans, aye. Jones? Knight? Aye. Knight, aye. Krikorian? Liu? Monning?
Aye.
Monning, aye. Silva? Aye. Silva, aye.
Very well. Mr. Leno, congratulations. That bill has the honor of the first bill getting out of our committee this morning.
Thank you very much. I appreciate your time and your support.
Thank you, Senator Leno. Senator Yee. Yes. Senator Yee, welcome. You are about a quarter of the committee's work this morning, so welcome.
Thank you.
So you're here on items number 5, 6, and 14. Item number 5 is SB 219.
Thank you very much, Mr. Chair. And first off, let me thank your staff for helping move this bill along and really take care of many of the ambiguities. First, let me take as author amendments the 18-month limit on how long the UC can take and hear these cases, and which is matching just simply the CSU time frame. This bill is a rather straightforward bill. Recently, there was a court case that talked about the fact that state workers, in fact, are protected by the whistleblower. There was some question as to whether or not the intent of the legislature was to include UC workers, and this bill clarifies that particular omission, and that's all this bill does. So this bill will then wrap UC workers into the state whistleblower program. With that, urge an aye vote, and I have Mary Alice Coleman as or Tom or Jim Hewitt and Tom Newton with the California Newspapers Association, and then also ASME and the Labor Fed.
Hey, very good. Your first witness in support, please.
Good morning, Mr. Chairman and Committee. My name is Mary Alice Coleman. I am an attorney in private practice in Davis, California. I have a number of clients who are whistleblowers for the state government, local government, and also for the Regents UC system. One of my clients in particular exemplifies the need for a bill such as this. We filed a whistleblower retaliation complaint with UC Davis in January of '08. The first 6 months involved correspondence going back and forth where they were demanding that we give more details and more names before they could start an investigation. Thereafter, an investigator was appointed at the end of July to meet with us as she left on a one-year sabbatical. In the course of the time, we now have had 3 extensions by UC on completing the investigation and coming up with some findings. And until that occurs, we cannot file a lawsuit and go into court. So I believe that this bill is very much needed, and I hope that you will support it. Thank you.
Thank you very much for your testimony. Your other witness in support,
Michael Bolton from ASME.
Good morning, Mr. Chair and members. Michael Bolden, representing the American Federation of State, County, and Municipal Employees. I'd like to just relegate my testimony to page 3 of the analysis. I believe that sums up for us exactly the essence of this bill, particularly in the middle of the analysis where Justice Werdiger expressed her concern. And she states, for whistleblowing employees to be confident they are protected against retaliation, they must have recourse to a fair and impartial decision-making process outside the line management of their employing agency or university. If the same government organization that has tried to silence the reporting employee also sits in final judgment of the employee's retaliation claim, the law's protection against retaliation is illusory. She also states, I do not believe the same legislature that created a civil action for damages on behalf of a whistleblower subjected to retaliation by the university could reasonably have intended the university to resolve whistleblower retaliation claims by way of its own internal procedures without any meaningful judicial review. I think that was very poignant remarks by the justice that we certainly agree with, and we also agree with the consultant's analysis, and we thank the committee's work on this bill, and we ask for your support as well.
Thank you very much. Others in support?
Terry Frank with Californians Aware, urging a aye vote in strong support of the bill.
Thank you.
Jim Ewart, California Newspaper Publishers Association, urge your strong support.
Thank you.
Jeremy Smith on behalf of the California Labor Federation, also in strong support.
Randall Hager on behalf of the 3,300 psychiatric physicians of the California Psychiatric Association. We're in strong support.
Casey Kaneko of Suter and Associates on behalf of the City and County of San Francisco in support.
Thank you very much. Are the witnesses here in opposition to this measure? Welcome.
Mr. Chair and members, Steve Juarez with the University of California. Let me first of all state that the University of California fully supports protecting the rights of whistleblowers in all cases, and also to ensure the need for due process for the employees who are coming forward in very difficult cases. However, at the same time, we believe it is important to protect the administrative integrity of the review process that handles such cases, and that is why we continue to seek amendments to SB 218. We fully recognize the importance of these cases and want to work with both the committee and the author on this. The committee analysis states that, in fact, with a minor amendment, this will parallel the UC process with the CSU process in terms of affording whistleblowers the right to redress in the courts. We disagree very vehemently that that would be the case. The addition of the amendment will not put us in parallel with CSU. If the committee and the author are interested in having us parallel the CSU provisions, we are happy to accept that. We will work with the committee and the author on that, but as it now stands, even with the amendment, we will not be parallel. In fact, what would happen is employees at the UC level, because Mr. Yee has artfully added a word to our current code as part of this bill that says, regardless of the decision we reach, whether we reach a decision or not, employees have the right to sue for damages in court, notwithstanding the final rendering of the administrative review process. That is not the same for CSU. If we want to parallel our provisions to CSU, again, we'd be happy to remove our opposition, work with the committee, work with the author, and move forward on this. Thank you.
Thank you very much for your testimony. Are there others here in opposition to this measure? Seeing none. Questions or observations by committee members?
If I may, Mr. Chairman.
Certainly. Mr. Tran.
Good morning, Senator Yee. Can you respond or address the concern that the university has in terms of the inconsistency with the legal complaints between the CSU and the UC system?
Okay. On the first point,
basically, the assertion is that the plaintiff can, or the complainant can still file the legal complaint pending or despite an administrative hearing.
What the amendment that UC is asking for is to allow a process whereby UC employees would in fact go through their administrative process. Right now, under the current system, UC is judge and jury, and so I believe that what UC is interested in is to try and get a favorable decision on their side and bring that as evidence into the court. I just don't think that one should disadvantage our employees with that particular decision. All other employees, in fact, can seek redress directly to the courts without those kinds of negative findings, and and I can understand. I think what UC is trying to do, but I would argue that that would be an exemption, or that would be an exception. Now, I think to the point that the good counsel from UC has made about CSU, we will look into that. I just don't think that one should, in fact, disadvantage any individual trying to seek relief, particularly if they feel that it is a legitimate concern to raise.
Thank you. Mr. Tran, have you further? Okay. Thank you, Mr. Tran. Other members of the committee with questions or observations? Ms. Brownlee.
Yeah, I'm just trying to further understand this. The analysis generally says that the systems are, if this bill were to become law, then the UC system and the CSU system would be identical in its process. And I'm trying to understand the differences between what this bill. What are the differences exactly, other than I think the allegation is that the whistleblower would be able to claim their costs in this particular proposed bill, and that's the difference between. And is that true? I guess I'm just trying to understand. Is that true? A difference between the UC and the CSU system, the way this is proposed in your bill.
The bill basically wraps the UC, into the rest of the state employees within the state of California, relative to the provision of the state code on whistleblower protection. If you pass this bill, if you vote in affirmative, what you do is to then wrap the UC employees into the state code and provide them with uniform protections across the board. I think what
just like any other government agency,
That's
and
correct.
just like the CSU system.
Now, I think Mr. Juarez has brought up that particular point, that in fact that is not the case for CSU. I'm not aware of that. I think that he's just raised that particular issue now, and we will look into that particular point. I think the amendment that Mr. Juarez wants us to take is to allow or to require that the UC employees go through an administrative process, which is different than what is currently in our code. And I can understand that, as I indicated earlier, because they want to be the judge and jury and probably have a more favorable decision for their side and use that as the basis for going into court. And I think that that is tying all of our UC employees with one hand behind their back going into court.
Thank you.
If I may, I just want to respond because, in fact, we are happy to basically change the current process we go through, which Mr. Yee has referred to as judge and jury. We're willing to submit ourselves to the court process and allow claimants to access the Superior Court for redress of their claims if they can overturn the administrative decision, just as is in the case of CSU. And so, again, I urge the committee that if part of this design is to have us parallel with CSU, we're happy to accept amendments to do that fully. And we would no longer be able to have us be the final decision point with regard to these cases. We're happy to give that up. We recognize that that's an important right for whistleblowers. It was inadvertently drafted, I think, before to give us that authority. And the president of the university, President Mark Yudof, has said, we need to correct this, but we also need to protect the integrity of the administrative review process, just as it is done for CSU whistleblowers.
Thank you. Senator, do you have further comments on regard to this colloquy here, or you prefer to move on?
Well, if I can just summarize, I mean, the first point that I raised, I think you've heard the good counsel from UC. They basically want to continue the process that they have right now of being judge and jury. Now, the only difference is that with this particular bill, the UC employees can, in fact, access the court. Right now, as you, I think, heard from my initial witness, right now, UC employees are just dragged through this administrative process with extensions upon extensions, and they never get any relief whatsoever. I think on the second point, as I indicated earlier, we will look further into it. The only reason I think that the good counsel has raised this issue of it being similar to CSU is because of the timeline that we have done just to match that, and that was, I think, at the request of your committee consultant.
The time frames are the same now, the 18-month period.
Exactly, and we agree with that. I don't think that there's anything more to it. Again, if there is, we will look into that.
Other questions or comments from members of the committee?
So I just wanted to follow up to say that that is the intention of the author, to make sure that there is parity and likeness between the CSU and the UC system and other governmental agencies.
That's correct.
Thank you.
Any further questions or comments from committee members? Mr. Yee, do you wish to conclude?
Urgent I vote. Thank you.
Okay. Very well. Is there a motion on the bill? It's been moved. Is there a second? Second. It's been moved and seconded. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran?
Aye.
Tran, aye. Brownlee? Brownlee, aye. Evans? Jones? Knight? No. Knight, no. Krikorian? Liu? Monning? Aye. Monning, aye. Silva? No. Silva, no.
Okay, that bill has 4 votes. It requires 2 more. Before we move on to your next bill, Senator Yee, if we could please take care of the consent calendar. Is there a motion to approve the consent calendar?
Move to approve.
Okay, and it's been moved and seconded?
Mr. Chair?
Yes. You may. Do you wish to pull that matter from consent or simply abstain from it? On which matter do you wish to abstain? Okay. All right, well, why don't we approve the consent calendar? A motion has been made and has been seconded to approve the consent calendar. Let's do so with respect to every item except item 27, about which we will simply call the roll, because we will not have, with this composition of a committee, we will not have an approval yet. So please, on the consent calendar.
Fear?
Aye.
Fear, aye. Tran? Aye. Tran, aye. Brownlee? Brownlee, aye. Evans? Jones? Aye. Jones, aye. Knight? Aye. Knight, aye. Krikorian? Liu? Monning?
Aye.
Monning, aye. Silva? Aye. Silva, aye.
Mr. Jones is sort of a deus ex machina from the background there. And so now, with regard to item 27, let us call that roll separately, please.
Fear?
Aye.
Fear, aye. Tran?
Aye.
Tran, aye. Brownlee? Brownlee, aye. Evans? Jones? Aye. Jones, aye. Knight? Knight, abstain. Krikorian? Liu? Monning?
Aye.
Monning, aye. Silva? Silva, aye.
Okay, and now that bill has been approved as well. Thank you for your patience, Senator Yee. We'll now proceed to your next item.
Thank you very much, Mr. Chair and members. All state employees who allege retaliations are allowed under state law to take their case to Superior Court after 60 days of administrative review filed by the State Personnel Board. This is based on a 2009 court decision called the Arbuckle decision, which interpret the existing state code. This provides or this poses a particular problem because unnecessary expenses are imposed on the state and on the whistleblowers in these particular cases where a whistleblower knows that at the outset they want to go to a Superior Court. And so requiring that they go through the 60-day administrative process, it just simply wastes everybody's time, including taxpayers' time too, and money. What SB 220 will do is to remove the requirement that all whistleblowers who allege retaliation go through the administrative process prior to filing with the Superior Court. And so this streamlines the process. They have that right anyway, and it will then save a tremendous amount of money with the State Personnel Board. We will take as author amendments clarifying the hearing process for the State Personnel Board and adjust the statute of limitation to match existing law. With that urge, and I vote. And I have Ruby Cornell, who is a whistleblower, and she'll testify.
Thank you very much, Senator Yee. Please.
Hi, good morning. Chair and members, my name is Ruby Cornejo, and I'm also representing Michelle Dilley, who could not be with us today. We both disclosed improper governmental activities by the State Department of Social Services Community Care Licensing Division beginning in 1999. Our whistleblower complaints are currently still pending before the State Personnel Board after 5.5 years and 101 days to hearing. I have been on the stand, or was on the stand, for 50-plus days. This is outrageous and has come at a great cost to Michelle and I, simply as a result of trying to disclose improper governmental activities and disclosing these in good faith, which was putting the health and safety of these clients and vulnerable people at risk. In prosecuting our complaints of retaliation, we have incurred in excess of $500,000 in legal costs, and the cost to the state exceeds over $1 million. I urge you to vote in favor of SB 220, which will improve the State Personnel Board whistleblower retaliation hearing proceedings by allowing whistleblowers who know they want to go to court to opt out of the administrative remedy and go directly to court instead of waiting 60 days, which is not law. This will save people like us, as well as the state, a lot of money, which would otherwise be wasted in a dual process. I hope you support this bill. Thank you very much.
Thank you for your testimony. Next witness in support, please.
Mr. Chairman, members of the committee, Randall Hager representing the California Psychiatric Association. It has been an unfortunate event in my life to watch one of our members go through the process of trying to raise issues that over a period of time dealt with increasing access to care in one of our state institutions, patient quality issues and patient safety issues. And to see him basically relegated to an office in a prison cell that he had to share with someone else, to have his patient load taken away from him, a program that he had established to represent patients in court, which is the first of its kind in the nation, was actually dissolved. And those acts simply happened because he dared to speak up. And instead of saying, okay, we hear you, but we disagree with you, the individuals in this case decided to take these kind of retaliatory acts. So this is a good person trying to do a good thing, and bad things happen to him. Today, for the last 6 months, he is not in state service. He was driven out of state service. He now works in another sector of the economy. The last thing I'll say is that I know of other members in these institutions who will not speak up simply because of the example that was made of this particular individual. And it's really too bad, because we have some exceptional physicians in our institutions, and they're doing great work, and they want to do better work. And it's really tough to watch them keep their mouths closed when issues could be raised. And for that reason, the Psychiatric Association urges your support of this bill.
Thank you very much for your testimony. Others in support?
Mr. Chair and members, Michael Bolden representing the American Federation of State, County, and Municipal Employees in support.
Others in support?
Mr. Chair and members, Terry Frank with Californians Aware, urging her aye vote. We're strongly in support.
Others in support?
Mr. Chair and members, Pat Moran with Aaron Reed and Associates representing the California Association of Professional Scientists in support.
Mr. Chair and members, Kobe Pizzati with California Statewide Law Enforcement Association in support.
Thank you. Any other witnesses in support? Are there witnesses in opposition to this measure? There is no stated opposition to this measure. Are there questions or comments from members of the committee? Mr. Tran.
My concern regarding the issue of administrative hearing is that we have a system set up, and basically this is a free rein, according to the reading of the bill, basically a free rein and unchecked option for the complainant to go ahead and file a lawsuit in the suit court. My concern is and perhaps it's a rhetorical question, but if you can answer, please do, and that is why would we even have an administrative process if the complainant can go ahead and file the lawsuit anyways? Mr.
Yee, do you take that as a rhetorical question, or would you like to answer?
I think it's a question that is worth clarification and answering. I think that the Arbuckle decision pretty much sealed our faith on that particular matter. But I think, secondly, this procedure, this bill, was recommended by a state agency, the State Personnel Board, and they saw the wisdom of what we're trying to do. And the reason why this is important, and the reason why, and I know Assemblymember Tran, you're concerned about state resources and what have you. Can you imagine if we, in fact, would require individuals to go through the administrative process, knowing that these individuals are going to end up in court anyway? And so the State Personnel Board was arguing that if we then made all these individuals go through that process, knowing that at the end they're going to end up going to court anyway, that we would be going through administrative processes with really no interest in that particular process. They just simply need to kind of go through that hurdle in order to get to court. And so it's a waste of taxpayers' money to make all those individuals go through the process, and then the State Personnel Board has to then put resources into it to further that particular process. So what this will do, albeit that it does, in fact, moves individuals towards the courts, but at the end of the day, it's going to save the taxpayer a lot of money.
Any other questions or comments from members of the committee? Seeing none, is there a motion on the bill? It's been moved. Is there a second? Second. It's been moved and seconded. Senator Yee, do you wish to conclude?
Urgent aye vote. And again, thank you to your staff for your help, for their help in this particular effort.
Thank you, Senator Yee. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran?
Not voting.
Brownlee? Brownlee, aye. Evans? Jones? Jones, aye. Knight? No. Knight, no. Krikorian? Aye. Krikorian, aye. Liu?
Aye.
Liu, aye. Monning?
Aye.
Monning, aye. Silva? No. Silva, no.
That bill is out, Senator Yee. Congratulations. And now to item number 14, SB 786.
Thank you very much, Mr. Chair and members. I'll be very quick in the description of this bill because I think Mr. Frank, through his example, is going to be a lot more persuasive and I think cogent on this particular matter. Anti-SLAPP statutes were introduced in 1992 by Senator Bill Blockier, who authored and passed the very first one. While SLAPP suits are masked as ordinary lawsuits such as defamations, they are generally suits without merit that are brought to chill the exercise of free speech and petitions right by threatening the defendant with economic sanctions. Under existing anti-SLAPP statute, the defendant of a SLAPP lawsuits can seek special motion to strike, which is an early judicial ruling and termination of a suit designed to curb free speech. Under the existing law, a defendant who prevails on his or her special motion to strike is automatically awarded attorney's fee. As you can imagine, this procedure is now being used to silence individuals who would like to redress some concerns to government, and this will provide a rather chilling effect on our ability to deal with First Amendment issues, open government transparency. So what this bill will do is it's narrowly tailored to provide an exemption on those situations that affects the Brown Act, the Bagley-Keene Act, and the California Public Records Act. And with that, urge an aye vote. And I have Terry Frank who will speak.
Thank you, Senator. Your first
members,
witness
I'll
in
be
support.
glad to address this, but I think Mr. Scheer would prefer to be the lead witness on this, the sponsor.
Okay. We'll defer to the choreography of the team here. Your first witness, please.
Thank you, Mr. Frank, and thank you, Senator. Senators, this provision is essential to correct for an aberrant court decision earlier this year that has the effect of jeopardizing enforcement of all of California's major open government transparency laws. By that I mean the Brown Act, the Bagley-Keene Act, and the California Public Records Act. The situation is as follows. The typical situation is as follows, to be addressed by this provision. An organization, a community activist, or a newspaper, or my organization, the California First Amendment Coalition, or anyone would file let's say, a request for public records, or, well, file a request for public records. And if that request is denied, and denied improperly, the only mechanism for enforcing the public records law is for that person to file a lawsuit. Ordinarily, if you file a lawsuit in that circumstance and you win, the plaintiff can collect attorney's fees. And ordinarily, if the state, if the agency that you're suing loses, the agency does not have an opportunity to get attorney's fees from the plaintiff unless the lawsuit was filed frivolously or purely for purposes of delay. Now, what happened here and what creates the need for this legislation?
Could I interrupt for a second? Senator, as you know, in the committee, 2 witnesses, 2 minutes each. If you wish to reallocate that time among your witnesses, that would be fine, because I can tell this may take another minute or 2. I'll leave that to you.
Okay. Okay. The bottom line is, as a result of a court decision, a government agency, now under the SLAPP Act, if it merely prevails in the case, may get attorney's fees against the petitioner in an open government suit. This, and that completely changes the law. The prior law, the law that was created with all of our open government acts, only allowed the state or a government agency to get the penalty of attorney's fees in an open government suit in the event that the suit was filed in bad faith, frivolously, or for other bad reasons. We need to restore the status quo before this errant court decision of earlier this year involving the Callaware organization and the Orange County School District. And this bill would do that. The California First Amendment Coalition strongly supports it. Thank you.
Thank you for your testimony. Your next witness, briefly, please.
Terry Frank with Californians Aware. It was our nonprofit organization and our former president, Richard McKee, a chemistry professor in Pasadena, who were unfortunate enough to lose this case trying to enforce the Brown Act and the free speech rights of a member of a school board. The court not only disagreed with us, but acting on an anti-SLAPP motion, dismissed the case and held that we had to pay the school district's attorney's fees. On the merits, we found it hard to believe that the court was right, and so we appealed. The Court of Appeal upheld the trial court dismissal. And the long and short of it is that our former president, Rich McKee, was saddled with more than $80,000 in the school district's attorney's fees and had to curtail his early retirement or timely retirement because it eroded his savings dramatically. We don't want to see this happen again, and I don't think you do either, and I certainly urge your aye vote.
Thank you for your testimony. Others in support?
Mr. Chairman and members, Francisco Labak on behalf of the American Civil Liberties Union. We support the SLAPP law. We support this bill. It's a good balance. We urge your aye vote. Thank you.
Others in support?
Mr. Chairman and members, Tom Newton, California Newspaper Publishers Association, also in support of the anti-SLAPP law and this bill. Thank you.
Thank you. Other witnesses in support? Witnesses in opposition?
Good morning, Mr. Chair and members. Elizabeth Howard on behalf of the California State Association of Counties, with great respect and certainly with sympathy for the case that has brought us here today in Orange County. We would simply point out that we do believe that this bill would inappropriately restrict the awarding of attorney's fees in those instances where the defendant does prevail, as was the instance in the Orange County case. The Supreme Court has confirmed that the anti-SLAPP is a legitimate defense tool for both public and private interests. We see the bill as potentially tipping the balance away from local governments and away from taxpayer money. It's used on a very limited basis, and for those reasons we do think it is warranted and is an appropriate tool that should remain available to local governments. With great respect for Senator Yee, we are opposed to the bill. Thank you.
Thank you for your testimony. Others in opposition?
Good morning. Natasha Carl on behalf of the League of California Cities, also in opposition.
Thank you very much. Okay. Colleagues, are there... Oh, I'm sorry, one more witness in opposition. Excuse me.
My name is Rochelle Young, representing the Community College League of California, and we also oppose this bill.
Thank you. Is there anyone I've overlooked in opposition to this measure? Seeing none. Colleagues, are there questions or comments on this measure? Seeing none, is there a motion on the bill? Is there a second? I'll second. It's been moved and seconded. Mr. Yee, would you like to conclude?
Just very briefly, as the analysis and again, thanks to your staff, indicate this bill would still allow attorney's fee and cost to be recovered where the suits are frivolous and lacking in merit. So it's not a blanket. One of the ways that we can, in fact, protect taxpayers' money is, in fact, if we can understand and find out what's going on in the government, this will provide that necessary protection. With that, urge an aye vote.
Actually, Mr. Krikorian wishes to sneak in a comment.
I'm very sorry, Mr. Chair, but I just have to ask this question. Mr. Yee, I was surprised when I saw this bill to learn that a government entity could be determined to be a person exercising First Amendment rights that would fall within the umbrella of the anti-SLAPP statute in the first place. Is that well established in the case law? And if so, did you consider legislation to address that issue?
I'm just a senator. I'm just trying to take care of one little piece of it. Peter, you want to add?
Senator, you raise a very interesting question. No, it is not well established in the case law that government entities may invoke the anti-SLAPP statute. And that would be an alternative approach to correcting the hole in enforcement of public access laws the way you suggest. In other words, another way to do it, would simply be to say that government entities may not invoke, as a general matter, the anti-SLAPP statute in the cases that we're talking about, and also in cases, for example, where First Amendment claims are made in state court.
Thank you very much.
This is a very, very modest step, and I'm proud to support it.
Thank you.
And we can, Mr. Krikorian's staff is eagerly awaiting the direction to get that bill prepared for next year. All right. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Aye. Tran, aye. Brownlee. Aye. Brownlee, aye. Evans. Jones. Jones, aye. Knight. Knight, no. Krikorian. Krikorian, aye. Liu. Monning. Silva.
Okay, that bill needs one more vote. Senator Yee.
Thank you very much.
Thank you
Mr.
very
Chair,
much.
members. Thank you.
What has been called Senator Yee's committee is now going to yield to Senator Calderon. Senator, you're here on item number 2, SB 109. As you're approaching the lectern, I should note that item number 1, SB 20, has been put over, as has item number 7, SB 242, item number 10, SB 348. Now, Senator Calderon, SB 109, item 2.
Thank you, Mr. Chairman. Good morning, members. SB 109 would enact changes intended to protect consumers who bid at these auctions for real property. The auctions targeted by this bill are the large ones, the ones they have in the convention centers, other large venues throughout the state, where hundreds of foreclosed properties are auctioned off on a single day. At the present time, California lacks any laws that protect consumers who bid at these auctions. My office has received many complaints from individuals who place bids at these types of auctions and then were very confused about why their bids were ultimately rejected by the banks who own the properties. We've also heard complaints from bidders whose bids weren't accepted by the seller and whose refundable deposits were actually held by the seller for several months after the auction, interest-free. SB 109 would address the root causes of these consumer complaints by ensuring that people who bid at the real property auctions, number one, have a clear understanding of the terms of these auctions, and number two, that they're able to get their refundable deposits back in a reasonable amount of time if their bid is not accepted by the seller of the property. I ask for your support on this measure.
Thank you, Senator Calderon. Do you have any witnesses in support? Are there any witnesses in opposition? It's been moved. Is there a second?
Thank you.
Are there questions or comments from members of the committee? Seeing none. Senator Calderon, do you wish to conclude?
Ask for an aye vote.
Very well. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Tran, no. Brownlee. Brownlee, aye. Evans. Jones. Jones, aye. Knight. Knight, no. Krikorian. Krikorian, aye. Liu. Monning. Silva.
That needs 2 more votes, Senator Calderon.
Thank you very much. Good evening.
Okay. While we await Senator Lowenthal, who has the last items on today's agenda, I want to point out first for clarification that on the proposed consent calendar, item number 23, SB 340, had been taken off calendar today and was not a matter on which we voted. And now Senator Lowenthal has timely arrived. We can take up his 2 items, SB 115, item 3, and SB 120, item 4. Senator Lowenthal, welcome.
Welcome. Thank you, Mr. Chair, members. SB 115 creates a religious exemption to the California loyalty oath. Thank you. Last year, 2 California State University instructors were denied employment because they believed the language in the current oath requiring them to, quote, defend the Constitution against all enemies, foreign and domestic, conflicted with their Quaker religious conviction to refrain from violence. The bill allows public employees to decline to take the current oath based on religious convictions, provided that they sign an alternative statement committing themselves to uphold the Constitution and fulfill the obligations of the job. We should not be asking people to violate their faith in order to work for the state of California, as long as they will uphold the laws of the state and fulfill the obligations of their job. I have witnesses in support.
Thank you very much, Senator Lowenthal. Your first witness, please.
Mr. Chairman and members, Francisco Labaco on behalf of the American Civil Liberties Union. As the senator indicates, this bill is straightforward. It accommodates an employee or applicant's religious beliefs, and at the same time affirms their commitment to uphold the Constitution and discharge his or her duties. It exempts elected and appointed officials. I'd point out that the alternative oath that's in the provisions of this bill was essentially pretty close to the oath that was pre-1952. It's a straightforward bill. We strongly urge your support. Thank you.
Thank you very much for your testimony. Other witnesses in support?
Matt McMurdy for the Church State Council. On behalf of Seventh-day Adventists, we strongly support this bill.
Thank you. Other witnesses in support? Are there people who wish to state their opposition to this measure? Seeing none. We have a motion. Is there a second? Second. It's been moved and seconded. Do members of the committee wish to comment or ask questions on this measure? Seeing none. Mr. Lowenthal, do you wish to close?
I respectfully ask for your aye vote.
Thank you, Senator Lowenthal. Let's call the roll, please.
Fear?
Aye.
Fear, aye. Tran? No. Tran, no. Brownlee? Aye. Brownlee, aye. Evans? Jones? Aye. Jones, aye. Knight? No. Knight, no. Krikorian? Aye. Krikorian, aye. Liu? Liu, aye. Monning? Silva?
Okay, that bill needs one more vote. Senator, before we move to your last item, SB 120, which in fact is the last item of business before the committee, at least the last bill before the committee, I want to state to those who may be listening who are members of this committee who are not here that this is the last item. We do have some items that require motions in addition to your potential votes, and I would ask that all members of the committee who can hear this message would please come to the committee so we can conclude our business in a timely way. Senator Lowenthal, item number 4, SB 120.
Thank you, Mr. Chair, and Chairman Fuhrer and members. SB 120 helps tenants caught in a foreclosure to maintain their utility services by addressing two issues related to utility services. First, the bill ensures that tenants in a foreclosed single-family home will be able to connect utilities in their own name. Not surprisingly, landlords in foreclosure often stop paying the utilities. Some utilities demand the back payments before restoring the services for the tenant. SB 120 stops this practice. Second, while current law requires utility providers to post a notice on a multifamily property if utilities are scheduled to be turned off, this bill gives tenants better actual notice. It does so by requiring a mailed notice in addition to the posted notice, and by extending the posting requirement to single-family rental housing. Many California renters are living in homes that are being foreclosed upon and taken over by banks. Often the original landlord set up and paid the utility bills as part of the rental arrangement. When that landlord loses the property through foreclosure and at the same time stops paying those utility bills, a tenant may not even know about it until he or she comes home from work and finds that the electricity or the water has been shut off. SB 120 will provide some notice and some rights to those tenants. I ask for your aye vote. And I have witnesses in support: Christine Minahan from the Western Center of Law and Poverty, Ron Coleman from Acorn, and other witnesses also in support.
Thank you, Senator Lowenthal. Ms. Minahan, please.
Western Center on Law and Poverty. We are the sponsor of the bill. More than 25% of the home foreclosures that are occurring now are occupied by tenants. I don't think I have to say anything more because the senator has covered all of the reasons. If you come home and you don't have service and you've got small kids or any of a number of things that could occur, you need to have had prior notice for basic necessity of life, and by the mailing and posting, you will have that notice. We thank you and urge a vote.
Thank you for your testimony. Next witness in support.
Ronald Coleman here on behalf of California Acorn. In California, utility shutoffs for tenants has become way too common. Very often, it's in lease agreements to make sure that the landlord is responsible for paying utilities. Residents that are living there are paying their rent responsibly, but are finding that their landlord isn't paying the rent and is also not paying the utilities and suffer utility shutoffs. One of our members, Tina Marie Williams of Oakland, actually had come home from work one day, got in the shower, and the water was cut off while she was in the shower. After that, the electricity went, and she suffered no utilities for about 2 weeks. We think SB 120 is extremely important and absolutely necessary to make sure that tenants get notice that utilities are going to be shut off and provide them with a mechanism to make sure that they can keep their utilities on if they want to transfer them into their name. We think that this will definitely protect tenants from the devastating and dangerous conditions that are caused by them having their utilities shut off. And we ask for your support.
Thank you for your testimony. Other witnesses in support.
Leilani, Asian Americans for Civil Rights and Equality, in support.
Others in support.
Casey Kaneka of Suter & Associates on behalf of the City and County of San Francisco, in support.
Other witnesses in support. Are the witnesses in opposition? Welcome. Please.
Chairman, members of the committee, my name is Manuel Zamorano, and I'm representing Southern California Edison Company. Let me say that we have the highest regard for the senator, and we also are very concerned about these foreclosures. But the way this bill is written, in our opinion, it looks like a solution looking for a problem. Last year, we had 15 complaints. We have 4,000,000.3 residential customers. That is a complaint ratio of 0.00036. So you see, as far as we're seeing, this is a very insignificant problem that's going to cause a huge amount of cost for us. Why? We're going to have to deal with the notice. We're going to have to post notice. And we have a problem here with regards to how this billing is done. We don't know whether the person who's in the house is a renter or an owner. When it causes a problem when the bill is sent to a different residence than the service resident. So then we have to assume that that person in the house is a renter. So we send our notice out. It takes 51 days in order for us to be able to disconnect the energy. On day 41, we send out a written notice. Between day 41 and day 51, we make or attempt 10 times to put through an automated call system to these people. The problem is that because we also have to deal with confidentiality of the customer, we cannot send another notice out till the 52nd day. That means that if a owner of a home was to simply have his bill sent to his workplace, we would not be able to start disconnecting till 61 days. Now, they say that how are they going to find out about it? Well, there's certainly a lot of renter handbooks, and once this is discovered and found out, it'll be in those renter handbooks. So we see that as a huge problem for us. Secondly, if our field manager comes to the residence and he is approached by the occupant, we will make arrangements to continue on with the electricity. We do not want to disconnect anybody. And let's say that we get there, we disconnect. The renter comes home, finds out that his energy's been disconnected. If he contacts us before 3 p.m., we'll turn it back on. Let's say that he gets home after 3 p.m. and his energy is disconnected. If he will call our field manager, and if we see there's a certain exigency of those circumstances, we'll come back and turn it on in the evening, and then we'll do it again tomorrow the following day.
Please conclude your testimony.
Oh, thank you very much. But let me say this. The way this bill is written, we're going to incur a huge amount of cost for very, very little addressing a problem that we think doesn't exist. Thank you.
Next witness in opposition.
Mr. Chairman, members, Will Gonzalez on behalf of the Sacramento Municipal Utility District. We just became aware of these amendments on Thursday. We don't officially have a position yet, but we do share the concerns that Edison just expressed.
Thank you. Other witnesses in opposition?
Jack Hawks, representing the California Water Association. We had somewhat of the same concerns. And on the single family, just so the members of the committee know, the water utilities already, they send a written notice to the occupant. They also are required to contact either in person by telephone, and failing that, they post a notice on the door. As far as the multifamily buildings and units are concerned, they're required to post the notice on the door 15 days in advance. In the latter case, in addition to the discontinuance of service notice, it's also what's already in the statute in terms of allowing other occupants to become the customer of record. As far as the legislative language regarding the single-family extension is concerned, one of the problems that we saw was the case where you have non-related residents or occupants, and they could, the way the bill's written right now, they could establish one of the occupants as the customer of the account, let the service go delinquent, and then change it to the next person, and then continue the pattern there, and there wouldn't be any remedy there. We just we're looking to fix that that problem. And on the multi-family side, with the water utilities, these are all master metered buildings. And we thought that the posting of the notice on the door for the occupants, in addition to the notification of the actual owner, was a more effective approach than mailing to anybody who rents here. And we just thought that would be more effective, and the additional mailing requirement would be more duplicative and not as effective.
Thank you. Other witnesses in opposition? Seeing none, are there questions? Mr. Jones has a question, I know.
Is the opponent's opposition limited to the notice provisions, or is it extend also to the provisions of the bill that would extend the right to a tenant to assume direct responsibility for the utility service?
We don't have a problem with the tenant establishing the direct billing. That's not a problem, and we would facilitate that when we came to the House if a disconnect had been ordered. Where we have a problem is extending the 10 days further than we already do. It takes 51 days now. This would be another 10 days, which would make it 61 days. And the reason is that if we have a customer of record who his mailing address, in other words, we send his mail to his office, not to his home. We don't know whether that person in that house is an owner or a renter. So that means that we would have to extend another 10 days to that owner, even though that owner lives in the house. So we're incurring additional costs. Another thing, we're going into a smart meter, and so we're going to have smart connect meters. That means in order to be able to be posting these notices, we're going to have to incur additional costs for additional staff. Again, let me repeat, we only had 15 complaints out of 4.3 million residential customers last year in the Edison service territory. It's a problem that the cost just doesn't justify what we're going to do here. And who's going to bear the cost of this? Every residential customer in our service territory. If there's a problem, we will address it. Edison does not want to cut people's energy off. We do everything we can to keep their energy on.
I'm still confused, though, because all the notice requires is that 10 days prior to notice you post and you send it to whatever addresses you have. It doesn't require you to go on a search and frolic to find other addresses. It's just whatever addresses you have.
Okay.
So I don't get it.
No, I understand your confusion, and the confusion is this, is that we have confidentially state and federal rules that we have to comply with, and that confidentiality requires that we cannot disclose anybody's billing record to anybody until the entire notice process has been exhausted. Well, because we don't know whether that customer is an owner or a renter, and the bill is being sent to a different place than where the service is being rendered, we then have to assume that the person who's in the home is a renter, so we have to wait 51 days and then tack on another 10 days. that creates a billing consequence, and it also creates a possibility for people to game the system. I'm sure that doesn't come as an unusual surprise. We have people who are habitually late.
Yeah, but
and this would give them another 10 days by simply transferring their billing from their home to their office.
But all this bill says is you post a notice on the door and you mail it to whatever address you have.
That's right.
So how does that divulge
Because
confidential information?
We can't post a notice on the door. Under our regular billing service, we can post a notice on the door and send the notice out at the 41st day.
Yeah, but this will be a new law that'll
Yeah,
say that 10 days before termination you can do exactly
but that tax on, remember, we can't send it out and violate somebody's confidentiality. We don't know if the person in the home is a renter or an owner.
Right. I'd like to, if I could, Mr. Jones, just thank you very much for your questions. Interrupt for a moment, because I know Mr. Lowenthal, I think, wishes to dive into this as well. Thank you for your question.
I would just like to comment that in existing law with multifamily housing, they already have a 15-day notice, so we're reducing that 15-day notice to a 10-day notice. So this is more stringent, less onerous than they already have to do to the multifamily tenants.
That's true. I mean, but we're incurring additional costs here.
Just one more question.
Of course.
Mr. Chairman. How would you provide the notice then, if you were czar of all the world? And I don't mean that. I mean, I don't mean to be pejorative, but literally, if you had the ability to decide how to do it, so that tenants had meaningful notice of the ability to take advantage of the opportunity to have service put in their name, how would you do it?
Well, the way we are doing it right now is that if we come to the residence and we're able to speak to the customer, the renter, we will extend the we will stop the disconnect and extend the electrical contract with them. We will enter into a contract with them right then and there on the spot. We do that right now.
But if they're not home when your person shows up to crank the wrench or
if they call us, we will come out.
But how do they know? If
their electricity is out, they're certainly going to know that.
Okay, but isn't that a little bit harmful? I mean, you know, if they have to go 24 hours without electricity.
Well, again, if it's a circumstance that requires it, and they call our service manager, and we'll direct them to the service manager. He makes the decision. We'll be out that evening.
Any suggestions on how to get them?
We'll be out the
any
following
suggestions
day.
on how to get them noticed before you cut it off?
Well, I think where we're at is that we have a situation in which we're trying to comply with the law and deal with confidentiality issues here. We can't violate a customer's rights. That's under state and federal law.
Okay, thank you.
Thank you. Senator Lowenthal, are there other questions, by the way? Seeing none, why don't you, in your close, help address the issues that you've heard?
As I understand what we're doing, and Southern California Edison is saying that there are reasons that they have difficulty in the mailed notice. There are federal issues, confidentiality. I would like to remind the committee that the East Bay Mud is a supporter of the bill, another utility. All the other electrical utilities are not opposed to the bill, have to do the same thing. It is only Southern California Edison. It is not Sempra. It is not PG&E. They have no problem with it. So I think that this is an issue that, and I understand that there may be some inconvenience, but we're trying to protect renters. We are even making it less onerous for renters of two SG&E renters of single-family homes than they already have to provide that notice to multifamily. 15 days. We've reduced it to 10. We think this is a reasonable bill, and I urge your aye vote.
Thank you very much. The bill has been moved in second. So no motion. Is there a motion on the bill? Oh, Mr. Jones.
Just a comment, and I am sympathetic to your concern and that raised by SMUD, but I don't think it's sufficient to say there wouldn't be notice. So I think, you know, if you have a suggestion about how to effectuate notice in a way beforehand that you could share with the author that would get the tenants meaningful notice, I'd certainly be interested in understanding that. But at the present, I'm going to support the bill and support what the author's trying to do, and because I don't think it's going to work not to provide some notice beforehand. So, you know, maybe now that SMUD has jumped in, maybe they have some bright ideas also. I'm not asking for them right now, but I, you know, and the author is extraordinarily accomplished legislator and someone who builds towards consensus. And I think if you've got some idea about how to accomplish this in a way, but it's got to be in advance. I don't think it works after the fact.
Yeah, and for what it's worth, to sort of put a close to what otherwise could be a reopened discussion for a second, the bill does go to Utilities and Commerce next. So if Mr. Jones' suggestion is something that the parties wish to take up, there's an opportunity for that in a policy context, not merely before a floor vote. So having said that, it's been moved. It has not been moved. I keep saying that it has and it hasn't. Is there a motion? Thank you. Is there a second? It's been moved and seconded. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran? No. Tran, no. Brownlee? Brownlee, aye. Evans? Evans, aye. Jones? Jones, aye. Knight? Knight, no. Krikorian? Liu?
Aye.
Liu, aye. Monning?
Aye.
Monning, aye. Silva?
That bill is out. Thank you very much, Senator.
Thank you.
All right, so here's our scorecard.
We'll work with you.
Item 1 has been, as I mentioned earlier, taken off calendar for today. Item 2 by Senator Calderon, I believe is short of votes. It's 4-2 with the chair supporting. Let's call the roll, please.
Evans? Evans, aye. Liu?
Aye.
Liu, aye. Monning?
Aye.
Monning, aye. Silva?
Okay, that bill is out. Item number 3 by Senator Lowenthal, SB 115, is 5-2. Chair voting aye. Please.
Evans? Evans, aye. Monning?
Aye.
Monning, aye. Silva?
Okay, that bill is out. Item 4 is out. Item 5 and item 6 are both out. Item 7. Oh, pardon me. Item 5 is a 4-2 vote. Chair voting aye. Call the roll, please.
Evans? Aye. Evans, aye. Jones?
Aye.
Jones, aye. Krikorian? Liu?
Aye.
Liu, aye.
Okay, that bill is out. Item 6 is out. Item 7 is off calendar. Item 8 requires votes. It has 3 votes so far. Chair voting aye. Call the roll, please.
Evans? Aye. Evans, aye. Jones?
Aye.
Jones, aye. Krikorian? Liu?
Aye.
Liu, aye.
Okay, that bill is out. Item 9 needs a motion. Senator Corbett was here at the beginning of the hearing. Is there a motion on item number 9? It's been moved. Is there a second? It's been moved and seconded. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran? Aye. Tran, aye. Brownlee? Evans? Evans, aye. Jones?
Aye.
Jones, aye. Knight? Knight, aye. Krikorian? Liu?
Aye.
Liu, aye. Monning?
Aye.
Monning, aye. Silva?
That bill is out. Item 10 is off calendar. Item 11 needs a motion. It's a Senate Judiciary Committee bill.
So moved.
Is there a second? Second. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran?
Aye.
Tran, aye. Brownlee? Evans? Aye. Evans, aye. Jones?
Aye.
Jones, aye. Knight? Krikorian? Liu?
Aye.
Liu, aye. Monning?
Aye.
Monning, aye. Silva?
That bill is out. Item number 12, Senator Corbett. It's an amendment to the State Bar Act. It requires a motion, please.
So moved.
Second.
Okay, call the roll, please.
Fear?
Aye.
Fear, aye. Tran? Aye. Tran, aye. Brownlee? Evans?
Aye.
Evans, aye. Jones?
Aye.
Jones, aye. Knight? Knight, aye. Krikorian?
Aye.
Krikorian, aye. Liu?
Aye.
Liu, aye. Monning?
Aye.
Monning, aye. Silva?
Okay, that bill is out. Item 14, Senator Yee, 5 votes. Chair voting aye. Call the roll, please.
Evans? Aye. Evans, aye. Liu?
Aye.
Liu, aye. Monning?
14.
Monning, aye. Silva?
Okay, that bill is out. All right, now, we have concluded our business. If there are committee members within earshot of this message, I need to be present in order for you to add on, and I can stay here for approximately 2 more minutes. So those of you who wish to add on should do so now. Otherwise, we are adjourned.